Cross-border M&A transactions offer foreign investors exciting opportunities in Vietnam. But when a deal reaches a certain size or market influence, it may trigger merger filing requirements under Vietnam's competition law. Failing to comply can result in serious legal consequences, including fines, delays, or even the invalidation of the transaction. In this video, we explain when a merger filing is required in Vietnam, what the legal process looks like, and how to navigate it effectively. Merger filing, also known as economic concentration notification, is a legal procedure under the law on competition. It applies to transactions where businesses merge, acquire control, or jointly operate in a way that could affect market competition. The filing allows authorities to assess whether the deal creates unfair dominance or restricts consumer choice. This applies equally to domestic and cross-border deals involving Vietnamese entities. There are 4 types of transactions that may trigger a filing requirement in Vietnam. One is a merger of 2 companies. The second is one company acquiring ownership or control of another. The third is a joint venture between independent companies. The fourth is one company acquiring all or part of another company's assets if it gives significant control. In all these cases, if certain thresholds are met, filing is mandatory before closing the deal. Vietnamese law sets specific financial and market thresholds to determine when a merger or acquisition must be reported. A filing is required if the total assets or total revenue of any party or its affiliated group in Vietnam reach 3,000 billion Vietnamese dongs or more, if the transaction value is 1,000 billion Vietnamese dongs or higher, or if the combined market share of the parties in the relevant market is 20% or above. When any of these thresholds are met, the parties must submit a merger notification to the National Competition Commission before completing the transaction. Not every merger or acquisition needs to be filed. If the transaction does not meet any of the legal thresholds or if the parties operate in completely unrelated markets, notification is not required. In addition, Vietnam's competition authority may apply a simplified review process for transactions that clearly do not cause market concentration concerns. For example, when the acquiring company has no existing business activities in Vietnam or the combined market share remains insignificant. Whether a deal qualifies for this simplified procedure should always be evaluated by legal counsel based on thorough market and financial analysis. Merger filing in Vietnam involves 2 phases. Phase 1 review typically takes 30 days from the acceptance of a complete application. If the authorities decide the deal may affect competition, it moves to Phase 2, which may take an additional 60 to 120 days. During this time, parties cannot close the deal. This makes merger filing a critical factor in deal timelines and closing schedules. Delays in submitting documents or responding to authority questions can extend the process. The merger filing dossier includes transaction documents such as the MOU or SPA, financial statements of the involved parties, market share analysis, and internal assessments of the deal. All documents must be translated into Vietnamese and certified as required by law. Any missing or inaccurate information may cause the file to be rejected or returned for revision. Early preparation of this dossier is essential to avoid deal delays. Merger filing in Vietnam is not optional. If a company fails to notify the authorities when required, it may face a fine of up to 5% of its total revenue generated in Vietnam during the previous fiscal year. In serious cases, the transaction may be declared invalid, and the parties could be required to unwind the deal or divest part of their ownership. These penalties are real and have been enforced in Vietnam. For foreign investors, ensuring compliance is critical, especially in large-scale mergers and acquisitions. One mistake is assuming that a foreign-to-foreign transaction is exempt from Vietnamese merger filing just because the deal is signed abroad. If one of the involved companies does business in Vietnam or has subsidiaries here, filing may still be required. Another mistake is calculating thresholds based only on group financials rather than Vietnam-specific numbers. These errors can be costly, and legal analysis must be precise. Merger filing is separate from M&A approval under the law on investment or sector-specific licenses. A deal may require both merger filing and M&A approval, depending on its structure and industry. Coordination is key. All legal steps should be mapped out in advance and submitted in parallel where possible to streamline the overall timeline. At LTS Law, we help clients assess whether their transaction triggers merger filing, calculate legal thresholds, prepare notification dossiers, liaise with competition authorities, and ensure smooth review. Our experience in both cross-border and local M&A gives us the insight to manage complexity and protect deal timelines. We also assist in building competition compliance strategies post-acquisition. Planning a cross-border M&A in Vietnam. Don't let merger filing derail your deal. Contact LTS Law or visit lts.com.vn to speak with our competition and M&A legal team. With the right legal support, you can navigate merger control with speed, strategy, and certainty.